welcome back. Welcome to the course, the afternoon session for Dance on the Blockchain. So I'm very happy because now we're going to be having a different angle or a different perspective around the same topic of dance, choreography, and copyrights in this case. So I'm happy to invite Simon Geiregat from the law faculty here in Ghent University. And in this session, we're going to be talking about who owns choreographic and other artworks, and what does blockchain have to do with it. Following an introduction to some general copyright concepts, this lecture focuses on the facts and figures surrounding today's digital and artistic ownership debates. Particular attention is spent to the emerging phenomenon of art NFTs, pleading for extra caution. A little note about our speaker. Simon holds a PhD in copyright law from Ghent University in 2019 and an LLM in intellectual property and IT law from Leuven University in 2017. His research focuses on the verge of IT technology and private law. He is a postdoc scholar at FWO Research Foundation Flanders, a visiting professor at Ghent University, and a part-time assistant professor at Universiteit Leiden. The floor is yours.
Thank you. All right, so we have 2 hours together, people, and what do I hope to talk to you about today? First of all, before the break, I would like to go into some topics like what is intellectual property, what is copyright, what do these words mean? Can you actually own a choreography? Can you own a way of dancing? Can you own a style of dancing, etc.? And what are your options? What can you do if you see that somebody else uses your choreography? So that's what I want to present you before the break, however long that may take. And then after the break, we will focus on the second part of my presentation, which is blockchain. So then we will bring in the idea of blockchain as a technology. What does blockchain mean for copyright in general? And then more specifically, what could it mean for copyright and choreography, with a specific focus on so-called non-fungible tokens, NFTs, which I presume that you all have had a proper introduction to already. Okay, so I got an understanding that we have 2 lawyers in the room who will now make themselves known to the audience. Okay, so these are the 2 over there. May I just quickly ask what other fields of research you are from?
Yeah, so in my case, performing arts and new technology.
Performing arts.
Performing arts. Who else performing arts? Yeah, obviously the majority. Okay, and then over here.
I'm just an artist.
Just an artist. Okay, that might be a bit of a statement. And you, sir?
Film and media arts.
Okay. So we have a very artistic audience. That's great, because then you can challenge me, or you can put your ideas next to what the law has to say about art. So, as already said by Jorge, this is how I would like to proceed. Before the break, I give you an introduction to intellectual property. First, some basics. We have to get through the boring parts first before it becomes really interesting. Then we get to copyright and neighboring rights in particular, which is more specific, more tailored to choreography. And then after the break, we'll go into IP and call it distributed ledger technology, call it blockchain. I will refer to it as blockchain because you know that these words are often used interchangeably. Good. So that being said, the screen is huge actually. Didn't anticipate that. Okay.
It's like
yeah,
a live stream.
It's really. It's yeah. Okay. Okay. Let's start where we have to start, and that's the basics.
Bellissimo.
Okay.
Bravo.
So whether you believe it or not, as a matter of principle, we live in a economy, in a society where, again, as a matter of principle, you are free to copy what other people invent, what other people create. There is no such thing as a general principle that in law that says that if somebody makes something, that you cannot copy that you cannot use that same idea, that you cannot make the same concept. And why do I show you a picture of a notion? Because often this principle, which is the freedom to copy, is referred to as a metaphor as an ocean of copyability, an ocean of freedom. But, and here is where it becomes interesting for us as lawyers, in that ocean there are islands. Islands, well, first of all, why am I pointing at the boat? Well, this is us navigating our boats through these islands, enjoying our freedom to copy. But just like a real ocean, the freedom to copy ocean also has islands in it, and these islands, these are the exceptions to the freedom to copy. Exceptions, yes, because in some very specific circumstances, if very specific conditions are met, then what the law does is it says, okay, we're going to put aside this principle, this principle freedom to copy, and instead we're going to give to somebody specific, to some specific actor in our society, we're going to give this person exclusivity, so literally the exclusive right, the monopoly to pursue certain actions, to copy something. So a veto right, a monopoly right on a certain thing. So we have different kinds of islands. You have small islands, you have big islands, you have huge islands, you have protected islands, islands where you have to pay to anchor, islands that you can conquer, etc. But keep in mind this allegory, the principle, the basic principle of our economy, of our society, is still that we can copy each other, but in certain circumstances there are exceptions to that. And these exceptions, so these islands, that's exactly what an intellectual property right is. So an exception to this freedom of copy, that is actually in its most basic form the definition of an intellectual property right, often abbreviated in English as IP right or IPR. So that's something you will find in all the IP law books. Okay, so now we have that as a basic principle. That brings us to the question, okay, yeah, you're talking about these exceptions, these islands. Now, what exactly does that mean, or why, when, in what circumstances do we have such an exception? In other words, why would the law, why would the lawmaker, why would the policymaker say that in certain circumstances only some people, only a limited amount of people has the right to reproduce, to copy a certain thing? Well, that is because in certain specific circumstances, the idea is that if we want to create an incentive for people to create something, then we have to give this person an award for that. For instance, say you want that your society produces more art, more literature, then you could incentivize artists, which is also happening at a smaller scale, by giving tax reductions. You can incentivize this by granting subsidies, for instance. But what better system than incentivizing somebody to make something than saying, hey, if you make something and it adds something special to society, then you will have a monopoly over that specific thing. The law protects you from other people trying to copy that thing. You are the only person who is allowed to copy that thing, and you decide who can and cannot copy that thing of added value that you added to society. So that's the basic idea behind an intellectual property right, is that there's always something that is added to society, and because you add something to society, the reward is a monopoly, an exclusivity. And this brings me to a list of features, properties, characteristics, call them as you want, that are proper to all intellectual property rights. First principle, which actually I already mentioned to some extent, is that an intellectual property is in its essence a monopoly right, an exclusive right, a veto right, I use these words interchangeably, that only exists if the law says it exists. So you and I cannot decide tomorrow to create a new intellectual property right. No, only if there is a law that says if you create that and you fulfill these conditions, then you will have exclusivity. Only if that is the case, you will have an intellectual property why is that important? Why can we not create mutually? Why can we not mutually create an intellectual property right? That is because only the law allows to get it to a system where everybody has to respect these rights. It's only because the law, which is voted, at least in theory, democratically in each country, only because the law grants this protection that everybody has to respect this, whether you like it or not. So that's the principle of legality, the principle of a legal basis. Every intellectual property law is somewhere in a law. Every intellectual property right is somewhere in a written law. Good. Then, every intellectual property right has an object, un objeto, a subject matter, has something that it protects. And that something that is always, as you can see on the slide in huge letters, it's always a creation of the human mind, in other words, an intellectual creation. So, what will we not protect, for instance? Simple information. Information as such cannot be protected through an intellectual property right. No, it's only if something is created by human intelligence that it will be protectable under an intellectual property right. What more does that mean when you say it has to be a creation of the human mind? That means that, for instance, discoveries, for instance, you discover a new flower, you discover a new animal in a tropical area, can never ever be protected by an intellectual property right. Again, why? Because the idea is to incentivize creations, and something which is already there does need to be incentivized, so it's only if you add something new, if you create something new, that the law will grant protection. In the same vein, and this will be important also for choreography, the law never protects a concept, a style, or an idea. So say you have a great idea to have a certain business model, selling something at a certain price and then buying it back and then selling it again. You have a great idea, or you have the idea to open a shop about a certain new product in a certain street. Well, anyone can copy that. Why? Because that is so anybody else can make such a shop, can copy your idea. Why? Because ideas can never ever be protected by intellectual property rights. Ideas are always free. This is under the principle of freedom of expression called free speech in the US. Good. Are we still following? Okay. Great. It's a bit abstract in the beginning, but it gets concreter and good. Because of this characteristic, so the fact that the subject that is protected by an intellectual property right is always a creation of the human mind, we also know that an intellectual property right always has an object that is so-called intangible. So what we protect is not a tangible object which is protected by an ownership right, what we call property rights. No, intellectual property rights deal with objects that are intangible. For instance, no, I'm going to add something more first, but intangible, so things that you cannot touch, things that you cannot perceive as such, can only be perceived by us as humans through tangible objects. And the result of that is that although an intellectual property right always covers an intangible object, you will only be able to claim protection if there is some tangible object, some perceivable object, where this intellectual property right, or where the subject matter of that intellectual property right is embodied. Okay, this is very abstract, but very simple or very oft-cited examples say that intellectual property right protects a novel. So copyright protects literature, so a novel, a beautifully written novel, will be protected by intellectual property right. Well then, from a legal perspective, what is protected is not your paper book, the paper book that you have that will be somebody's ownership, so somebody will call himself the owner of that paper book. No, when we're talking about intellectual property right, then what we're actually saying is that somebody has rights, somebody has an exclusive veto over using the exact order of words that is used in that novel. As long as that novel is in somebody's head, of course, we don't know, there's no way to prove that a person had this idea at first. So that's why I'm saying it's only if something, once something is out of somebody's head, once it is incorporated in something tangible, like a paper book, that an intellectual property right will be relevant for us, because otherwise there's no way to prove that you were the first one, for instance, to think of the exact sequence of words that J.K. Rowling had in her head when writing the Harry Potter novels. Okay, so difference between a tangible object and an intangible object. Now, why is it important to stress that the object of an intellectual property right is intangible? A couple of things follow from that. First, it does not matter who is the owner of the physical copy that you have, the tangible copy that you have. It does not matter where J.K. Rowling's books are sold, where her novels are anywhere in the world. The fact that these books change hands, and the fact that multiple copies of these books are printed has absolutely no influence, no impact on her copyright. It's not because you buy a painting, it's not because you buy a novel, that because of that you are now entitled to copy that novel, that you are entitled to copy that painting, that you are entitled to make alterations on that painting. No, the intellectual property rights, in this case copyright, stays with the author. So this is the so-called principle of independency or autonomy. So at a certain point you will have an object, something tangible, and on the one hand side you have to determine who is the owner of that object, so who has the right to physically use that object, but this is independent from the question who has intellectual property rights in that object. Good. It's a bit abstract, I know, but we'll get there. It's going to be more and more. Another basic principle, the other principles are a bit shorter to explain, so I'm happy for you, is the fact that there's always a threshold. And that's what I said before. So the law grants protection to certain subject matters, certain creation of the human mind, but not every creation of the human mind must be incentivized. No. If you want to have an exclusivity, if you want to be protected by the law, if you want a monopoly for your creation, then your creation must meet a certain threshold. It must be something more than the usual. It must be something more than something, what's called in legal jargon, banal, something more than banal. And there is where the difference is between various intellectual property rights. So I'll give you a list right away. There are different sorts of intellectual property rights, and each of these intellectual property rights protect something else which has to meet another criteria. For instance, you want to protect a technical invention, so something you invent, say, in your laboratory, a new way, for instance, of conserving food. So then the object that you want to protect is invention, so your subject matter, your object is an invention. When will you be able to protect an invention? Well, the law says your invention has to be inventive. In other words, it has to be, and then the question would be, when is this the case, when is this not the case? And that's where there are books about these kind of topics in the law. The question will become, is this something which a normal inventor, a normal skilled person would have been able to do, or is this something that required a step that goes beyond what is normal? And only if what you did was spectacular, was more than what an average inventor would have invented, then you can, in this case, apply for a patent. So that's the idea of a patent. And in the same sense, for instance, you can only get protection for a mark, something that indicates the origin of a product, a trademark. You will only have protection for a trademark if you can prove that your trademark is distinctive. In other words, that other people recognize your trademark as an indication of origin, etc. And in the same sense, we will see in copyright that copyright has as the object a work, and this work has to be original, and then the question becomes, what is original, what is originality? So only if you make a work that is original, you will have protection under intellectual property. Good. I know it's a bit abstract, but again, it gets more concrete after the very basic introduction. Some other relevant principles which I'm just going to mention. Principle of territoriality. Unlike what you might think, there's no such thing as an international intellectual property right. No. If you want to know which rights you have to look into each country separately. So every country has their own system of intellectual property rights, which means that if you go abroad, you cannot take your intellectual property rights with you in a backpack. No. If you want to know whether you have protection, for instance, copyright protection in the Netherlands, then there's only one solution. You take the Dutch copyright law, and you look into it, and you ask yourself, do I fulfill these conditions? Now, fortunately, countries have been collaborating in the field of intellectual property right already since the 19th century, and because of that, I would say that in 95% of the situations, you will have the same rights wherever you go, but of course, it gets interesting in the 5% where there are differentiations. Another principle that is that, so the idea is you want to incentivize a certain party, you want to incentivize a certain person that made something, that added something to society. Well, this incentive should not be perpetual, so all intellectual property rights are limited in time. They're always restricted as to their duration. For instance, a patent can only can only be as long as 20 years. So if you invent something and it is inventive, so it is special enough to protect, then you can have a maximum protection of 20 years. In copyright, it's a lot longer. We'll get to that again after my introduction. There, it's the full life of the oldest author plus 70 years. So that's the term of protection for copyright. I think that's quite a known fact. I think a lot of people know that. So restrict this to the duration. Once your rights have expired, then they say, then it's a commonplace to say that your rights or your object matter, your work, is from then on in the public domain. So if we're talking about, for instance, copyright works that are in the public domain, that means that we're talking about works for which the rights are where the rights are no longer valid, where the period of time has passed. Good. Then there are two ways where intellectual property rights get attributed to a person. For some intellectual property rights, you need to pass by a government institution. You have to register your right, which is the case for patents. You have to apply for a patent, and then the government says either yes or no. You get your patent or you don't get it. But the intellectual property rights that will be interesting for us today are automatically granted. Automatically, which means that the moment that you fulfill the criteria in the law for protection, well, automatically from that moment onwards, you have this protection. You're entitled to that protection. You don't need to register. Last but not least, the principle of accumulation. One and the same object can perfectly be protected by multiple different intellectual property rights. Take a smartphone or a laptop. You'll find a trademark on that. That's one intellectual property right. There are probably a lot of inventions in it. So the technology, for instance, to make the motherboard of your smartphone or your laptop will be protected by patents. There is software on your laptop, on your smartphone, so that will be protected by copyright. The design of your laptop will be protected by design rights, etc., etc. Well, that's absolutely possible. Intellectual property rights can be accumulated in one object indefinitely. And these, my dear audience, are the basic principles of intellectual property rights. And from here on, we can now go a bit further, unless there are any pressing questions. No?
Maybe just to illustrate something that will contextualize for our audience, and since we are, some of us, a lot of us are working in the performing arts, it's definitely relevant to see how the same object can be intersected or protected through different resources, or like the different lines that Simon has explained. And there's this historical example of Louis Fuller, this dancer, modernist dancer, that was using these large fabrics, like using to kind of create this shape of moving flowers in the air. And she couldn't protect through copyrights her creations because they were not considered innovative enough for that time. They were considered like, yeah, you're just moving, you're not doing anything in particular, you're not conveying any story that is relevant. And she then applied for a patent because she said, okay, if this path is not going to give me protection over this creation, maybe I can use this other, but it's around the same creation, around the universe of dance, and there are like different aspects of it that you could try to get it from, right?
Yeah, that's interesting. And one of the things you said, I'm going to go into detail a bit later in the copyright part. Because if we take a look at the intellectual property rights that exist, okay, this is not a definite list, so this is not a closed list. There are other intellectual property rights, but these are the most important ones. On the left side, the red box is what is called, was traditionally called artistic property, which is used was used. That was the idea behind it, to protect artists, to protect creativity. While on the right side, we have these intellectual property rights that protect industries, that give monopoly to protect certain investments. So that's a classical dichotomy between two different intellectual property rights, but today that classification is not entirely correct anymore. For instance, because computer programs are also protected by copyright, and databases are also protected in this, are also divided in this category, whereas actually databases and computer programs should be in this list of subject matter protected, because it's an investment that needs to be returned. So why do we still use this distinction? Because one important common characteristic is that, although there are exceptions too, is that the ones on the left do not need registration, so the law gives you your rights automatically because you make your creation, whereas the ones on the right, the industrial property rights, are only granted after you register them. So for the rest of today, I'm only going to focus on these three intellectual property rights, because these three are the most relevant ones for choreography today. First and foremost, there's copyright. Copyright in the Anglo-Saxon terminology, in what used to be called continental European systems, or systems derived thereof. We talk about author's right, derecho de autor, direito do autor, I think in Portuguese. And then there are the neighboring rights, on the other hand, which are like light versions of copyright, which also grant protection to a certain choreographic phenomena. So we'll kick off with copyright, which is by far the most important intellectual property right in choreography. What can I tell you about choreography? What can I tell you, about choreography? Probably you can tell me a lot more than I can do to you. But about copyright, I'm sure that I can teach you at least some things. First of all, as I already told you, an intellectual property right always protects something, something protection worthy. Well, here the idea is that protection is granted to an original creation, and notably an original work. And then in the next slide, I will show you what exactly is meant by an original work. How do we interpret, how do we read those terms? And as I already told you, copyright is attributed automatically. So the very fact that you fulfill the conditions that I'm going to tell you after this introduction slides, the very fact that you comply with these conditions automatically ensures you that you will have a certain protection, that you will be entitled to a certain veto right. But beware, because it's not because you know that you are right, it's not because you know that you are entitled to copyright that you can always prove that you have copyright. That's a very important principle in law. Make sure that you're able to prove that you have the rights that you claim you have. Make sure that you can always prove that, for instance, at a certain time you made a certain creation, you made a certain work, because, of course, if in a later case somebody imitates you and you cannot prove that you were the first one and that you were copied, well, then obviously, basically said, you are screwed, because there's no way, if you cannot prove, that you will convince a judge about you being first. There are no formalities, so you don't need to apply, you don't need to register to get copyright law. I'll even say more, it is prohibited from an international law perspective to require you to make a registration. So no government, in principle, can oblige you to register for copyright protection. As a matter of principle, you should get copyright protection automatically because the law says so. Although a small nuance here is that principle, because of international law, only applies to foreign nationals, and now it's getting a bit complicated. So the consequence of that is that it's basically only a problem in the US, and that is that in the US, if you are a US author making something in the US, then you will only have copyright protection if you register your work with the US Copyright Office. But we, as foreign authors, we will get automatic protection because of this international law telling us that we are entitled to this automatic protection. It's a strange rule, but it's something that actually is very specific for the United States. In Europe, it's very simple. In the whole of European Union, the principle is that everything that counts for foreign nationals also accounts for European nationals. We used to have a system in a lot of countries where you had to register, where everyone had to register before getting intellectual property protection, before getting copyright protection. For instance, I looked it up, in Ecuador and in Brazil, in both countries, registration was abolished only a couple of decades ago. Good. Last but not least, when we talk about automatic attribution and registration and stuff like that, then you might ask yourself, what is this? Okay, you see this sign popping up now and then. This is the copyright sign. Who can use it and when are you entitled to use it, etc. Well, in Europe, this sign has never had any specific value. But in the US system, you used to be only entitled to use the C symbol if you had acquired registration of your work. But as I say, for us, that's no longer relevant. For us, as non-EU, not US citizens, and from now I'm going to focus especially on the European system because that's the system I know best. But for us, as from a copyright perspective in Europe, the use of that sign is absolutely free. So, meaning that if you think that you made a copyright protected work, then you are absolutely free to use that C sign with your name. And then traditionally, what is used is you put the C sign, then your name, and then the year of the creation of your work. So there's no obligation to mention this. Why could this be interesting to mention it anyway, the copyright sign? Because the moment you mention copyright, the moment you show people that you think or you reckon that your work is copyright protected, there's no way that they can say, I didn't know it was copyright protected. So it's like a memo trick for your readers or for people that want to copy you by saying, yeah, look, this is copyright protected, so attention users. In the US, small exception, if you place the copyright symbol on works that are distributed in the US, you are entitled to higher indemnities. You can claim more money basically if you have a copyright infringement. Again, because of the same idea, because people that see that copyright sign should know or should have known that they were doing something that they were not entitled to.
So if we want to sell your presentation in the USA, we're gonna earn a lot of money.
Only if somebody else then copies your work and you successfully sue them before a U.S. court. So, but main message here is if you want to use the C sign, you're absolutely welcome to do it. It's not prohibited. It's even encouraged to do it in some legal systems. Good. When we're talking about copyright, then what is actually being protected? So what does copyright protect? As I said, works. What are works? Well, works can be in any type of art, say in visual arts, but also architecture, literature, and audiovisual works, but also, and that's of course something I will slowly, gradually get you through, will also protect choreography. Good. So, copyright protection will be granted to works. Two conditions for copyright protection, I already told you. First, you have to be there has to be a work. In old legal texts, you will find a work of art or literature, but today we shorten that. We just say work, and that work needs to be original. So originality is the threshold criteria that I told you. So the minimum threshold that you need to pass in order. And in a courts, because that's where you only get your answer the moment you get to court.
Yeah.
So if this is brought for a court, the fact that you try to claim copyright protection for 3 steps would be used against you because it's too few. Even if they are the most original movements, they will probably consider it to be too short for the whole work to be original. I know it's fake. However, it is irrelevant, first of all, whether your performance is really long. That's considered explicitly irrelevant. So the fact that you have a performance of 2 hours or 5 hours, yeah, that per se is irrelevant. You can have very repetitive choreography, for instance, so you will not automatically get a protection because you have a long performance. It's also irrelevant whether your choreography is part of another work. Say that your choreography is integrated in an opera or in another or in a theater, for instance. Irrelevant whether there is music added is also not relevant. And then something was mentioned already. It is explicitly irrelevant whether your work is storytelling or not. So it does not need to be a message that is being conveyed, a story like dramatical work would have. No, there doesn't need to be a factual story being conveyed to the audience. So then what do we do, for instance, with spontaneous dancing in a disco? Well, they'll probably not be protected because they'll usually be too banal, too simplistic to get protection. What do we do with folk dance? Will also not be protected, usually because it's a style, and if not because because if it was protected once, the protection will already have elapsed. Cases that are often also challenged for courts are sports. To what extent can a football player claim copyright in his or her movements on the field? Well, the answer is none, because the movement in sports like that are determined by the rules on the one hand side, and on the other hand by a technical requirement, because what you do as a player is responding to another player. Yes?
And just an interesting illustration, there were like 2 athletes in the US that were bothered because they were included in a video game. Well, their identity was being used so that users could play the sports that they were famous for performing. And since they, of course, did not own copyright for their movement, they were suing the company, I think it was Electronic Arts, for the rights of publicity being violated, or the rights of identity.
That's, however, another branch of the law. Still, that's the question if somebody can use your image. So these are image rights, and that's something that depends on from one country to another. Which is also very interesting discussions, because to what extent should you be allowed to have exclusivity over the use? Over the use of your
yourself.
own image? Is this part of your properties? Is it part of your privacy? Etc. However, there are sports that are that involve a certain creative choices, though. For instance, say ice skating, or back to my slide. Say ice skating or synchronized swimming, for instance. There you can say that there is that there is a choreography. 3 more minutes and then I'll have the break, although I'm not half where I wanted to be at this point. So very difficult to say when protection is due. The 3 steps Dan already gave. Questions that are currently debated in literature. What do we do with dance not performed by humans? So say dance performed by an avatar, well, it would be equally protected as a dance exercised by humans. So actually that's not so very much debated, as long as you are the author of an original work and that work is being reproduced by somebody else, whether that's a person or an avatar, an animated figure is irrelevant. The fact that your original elements are copied is sufficient to by copyright protection. What do we do with choreography designed by artificial intelligence? These are trending questions nowadays. Is this something for the near future, for the far future? We will see. At the moment that there's no creative choices, free choices made by a human, the majority point of view is that these works are not protected by any intellectual property right, because otherwise why would you incentivize a machine to make something? Who would we give a veto, a monopoly right to if a machine creates things anyway?
Simon, sorry, just a quick interruption
Yeah.
in there, because it's something close to the work that we do here. One of our colleagues at University of Oslo, Benedict, she created an AI model, and she was teaching the AI model how to dance by feeding it motion capture data. And then she was expecting for the AI model to produce its own dance steps, and of course the AI model was dancing in the most ridiculous ways after like regurgitating all the motion capture data. And then once that it was produced and she had these videos of the AI model dancing, and we didn't really know, we were like, well, who is the owner of this? Because
that's a very hot topic in copyright law. The
to
persons
this
who
point
made
it's
the
not
free and
protected,
creative
right?
choices. Who made free and creative choices in your process?
I guess the designer of the AI model, huh?
Depends.
In that case, she will have to protect the software behind it instead of like the dance that
No,
it
the
produced.
software behind it has no influence on the protection of the output. But if, for instance, you say it made crazy movements, and then she said, I'm going to add this, I'm going to alter this, that's a free and creative choice. That makes her the author.
Because of those editings and those corrections.
If she had free and creative choices at that moment, yes, then she would be the author. Okay, then choreography is something that barely makes it to courts. So that makes it for me and for you difficult to predict what a court will say. And I also read that between the lines in one of the articles that Jorge sent me and wrote. So what does this all mean? It means that although I give you these nice theories, you'll never know whether a court will completely agree with that. There are other disciplines that have the same problem. For instance, graphical designers who make type fonts, tipos de letras, have the same problem, because how can a letter be original? While there is a huge amount of free and creative choices involved, although for us, for the untrained eye, they may be irrelevant, in that branch there are a lot of choices being made. So they are also they have the same feeling as you, as perhaps as feeling discriminated because of their art form being less tangible or less known to the common public, including a judge, including to lawyers. So what is the solution for that? Well, one way would be thinking, let's just change the law and make a specific law for, let's say, for choreography. But actually, that's not necessary. First, it's not going to happen. It's not going to happen happen. They're not going to change the law for choreography. They're not going to do it for
It's not gonna happen.
anyone else's law. Because there's no political interest, because the tendency is now to give less and less copyright protection, and especially because your lobby groups are far too small to influence the European lawmaker.
Yeah,
What you
say it.
what you can do though is the things that you can do is sensibilize. So how do you do that? By explaining to normal people, well, I mean to people outside of your field,
The real people.
non-artistic people, to being more assertive and sensibilizing and telling, yes, we do make free and creative choices, and they are here, and they are here, and they are here, and to make that more tangible. How do you do that? Yeah, sensibilization
Marketing, yeah.
campaigns is one thing, but also writing about that. Write legal literature, or try to write literature about
That's where we
your
came.
topics and get that published. And that's the way that you can influence this debate. Of course, I know that's overly simplistic for me to tell, but this is the way that I think would be most favorable to choreography. And then, as I said, I have found that lobby groups in the choreographic sector are rather underrepresented. You will know, for instance, that pop music has huge lobby groups. They have these collective management organizations. Well, nothing stops you from doing the same. Although I know that it's a well-known phenomenon that a lot of artists like to work solo. Like they don't like to involve a lot of other people with their work. But if you want to get somewhere in a democratic system, then you need to stick together and find a way to protect your interests. So you have these big collective copyright management organizations for other types of works, say for literature, say for music. What do? They defend your rights collectively. They do lobby work. They sensitize people that you cannot plagiarize, that you cannot pirate music, etc. And they also claim, they will also help you in claiming money back from people that violated your rights. So is there something like that for choreography? Well, I looked it up, and yes, there is. I already showed you the slide by accident. It's called SACD, Société des auteurs et compositeurs dramatiques. French in origin, but they have a Belgian branch, and they have a Quebecan branch, apparently. For some reason, they are well developed in the French-speaking parts of the world. As to other countries, I did not immediately find a society that specifically targets choreographers very specifically. But that's a step where that's a point where you can start. If you want to do more for copyright for your branch of the art, for your genre of the art, then that's a place where you can start. Okay, brings me to the question. And so for the next part of about copyright, I'm going to be going a little bit faster so that we can get to blockchain in a couple of minutes. Question you may ask: okay, now we know what copyright is or when copyright is granted. Then the next question usually is who gets copyright protection, and the answer is
Nobody.
simple, but then again overly simple. The copyright protection is always due to the author of a work, and the author being the physical person that made the free and creative choices, person or persons, because it's obviously also possible that a work is made by different people at the same time. As long as everybody made an original contribution to a work, then everybody will be a what's called co-author or joint author, and the rights, the copyright, will be in the hands of these people together, meaning that you can only exercise your rights if everyone agrees. Applied to choreography, imagine that you have one person that you are experimenting with a number of people about a new choreography. One person calls himself or is called by the group the choreographer. Will this be the only person that is the author of the final work? No, if the dancers in the room also make free and creative choices during the session, then they will be joint authors. They will also be entitled to copyright. If you make a joint work which can be separated into different bits in different parts, and you can tell actually this part is made by this person and this part is made by this person, then according to some laws, including Belgian law, you will only be entitled to your part. But the moment that it's no longer possible to prove who made which part, the copyrights, the law supposes that everybody has made the same effort, so you are entitled to, if you're 2, 50%, if you're 3, 33% of the rights. These rules of joint authorship also apply to what's called derivative works. So there's a choreography which already exists, and you start from that choreography and create a new choreography or any other art form. Well, you will be the joint author together with the previous author. You will have the rights together with this previous author, unless of course the rights are already expired. For instance, say you take sheet music by Mozart and you add original elements, well then the whole work as it is created by you, your original elements will be protected by copyright. Of course you will not get exclusive protection for the part written by Mozart. Good. Also interesting here is to mention that the law protects the person whose name is on a work. So the fact that you mention your name on a work creates a legal presumption that you were the author of the work, unless somebody can prove otherwise. So that's another reason why you should put the copyright sign and your name on everything you do. You can do so in the metadata of a file as well, or if you write something down. The fact that you put your name on a certain file makes that the law protects you, unless somebody else can prove that you were not the maker, the author of that work. But just like any other right, it's perfectly possible to convey your rights, to transfer your rights to somebody else. In other words, to conclude a contract, an agreement with somebody else, and to exercise your rights in this way. Why would you do that? Because, for instance, you write a novel, you go to a publisher, then the publisher wants to be sure that he will be the only one publishing, so they will ask you to conclude a contract. And whether this other person is a physical person or what's called in law a legal person, like a company or an NGO or whatever, doesn't matter. You can convey your rights to upon someone else. And then we see that there are two types of contracts in intellectual property right and copyright and specific. You can convey a license or you can transfer your rights. If you transfer your rights, then it's simple. It's like selling your house, selling a book. After you transfer your rights, you don't have them anymore. Simple. It's like selling. Transfer, you should compare that to renting your rights. So you can rent your rights to somebody else. You license your rights to somebody else. Meaning, license literally means permission. A license is a permission. So you give permission to somebody else to use your work, and then you determine the conditions under which this person can use this work. For instance, only be used for the Belgian territory, only be used for a professional audience, etc., etc. Which rights you convey, that's absolutely up to you to decide. The law gives you, as an author, gives you the position to shape your licenses as you want. Two specific elements I want to stress with regard to contracts. Watch out, because if you are an employee employed by an employer, then it's possible that your labor contract says something about your right, and then depending on the jurisdiction you are in, so depending on the country that applies to your contract, the law sometimes automatically transfers your rights by the fact that you make a work while you are working with your employer. In Belgian law, that's not the case, at least not for choreographic works. So there, as long as your contract does not say that your rights are transferred automatically to your employer, then you will be staying the copyright holder of your own work. Nowadays, second thing I want to say about contract, nowadays we conclude contracts online as well. You create an account on TikTok, you create an account on YouTube, you will have to accept terms and conditions. Are these terms and conditions valid? Absolutely. These are legally enforceable. Of course, there are principles that you cannot violate. I mean, you cannot agree to give away your firstborn son, for instance, in terms and conditions, but unless proven otherwise, the principles in terms and conditions, the terms and terms and conditions will be valid, and you will see that in TikTok's or YouTube's or Instagram's conditions, there's obviously a license that you transfer to them for them to do actually whatever they want with the content that you upload. So this is also something you have to always take. Good. This brings me then to the core of the copyright topic. That is, okay, now we know when we get protected, who gets protection. The last question that still has not been answered is then, what does that protection look like? What rights do you have when you are an author? And we see that there are two different sets of rights that apply to copyright protected works: moral rights and patrimonial, also called exploitation rights. Moral rights were created with the idea that an author, a writer or a painter has a sort of moral connection with his or her work, and that this person should also always be able to maintain that moral, that personal love connection with the work that they made. And therefore, moral rights are, in countries where moral rights are protected, which is the case for most continental European and continental European systems and systems based on continental European systems, where moral rights are protected, these rights are non-transferable. So you always keep your rights, whatever contract you conclude, you always have your moral rights. Your exploitation rights, on the other hand, are exactly what they say on the tin. Exploitation right is meant for you to be able to get money out of your work. And that's why they call it exploitation or patrimonial rights, because you get money in return. Exploitation rights are transferable. You can also waive your rights. Waiving a right is when you say, I don't want to transfer them, I just want to transfer them to the public domain. So what you say is, I give up my rights, I do no longer want my rights. You cannot do that with moral rights, but you can do that with exploitation rights. Moral rights depend from country to country, and the duration also depends from country to country. For instance, in France, they are perpetual. So as long as you find some heir that says that my grandfather would not have wanted this, then he can go to court, prove that, and indeed oppose the use of a certain work. Whereas exploitation rights are subject to prescription, as I said, 70 years after the author's death, and if there are multiple authors, the oldest author's death, plus the 31st of December. So all copyright expires always every year at the 1st of January. But again, you have to look into every country separately. Then, what moral rights do we have or do exist? Well, internationally and in most legal systems, there are three moral rights that always come back. First of all, there's the paternity right, also the right of attribution. Seems logic, but if you think of it, there has to be a legal basis to confirm this. You have the right to be recognized as the author of your work. If you are entitled to copyright protection, then you have the right to be mentioned as the author in relation to your work. Say, for instance, who is this? Yeah, actually not. It's Paul van Haver, and Paul van Haver wants to be called Stromae. Why is that possible? Because this paternity right also gives you the right to be either anonymous or to use a pseudonym. So as an artist, you have a right, a legally protected right, to choose a pseudonym or to use or to anonymously distribute, diverge your work. Violations to the paternity right, especially with regard to choreography, are legion today, because on TikTok, everybody copies each other without attribution. In fact, from a Belgian law perspective, these are all copyright violations. Another right that every author gets, and again, you cannot give these rights away, you cannot transfer these rights, you cannot waive these rights, is the right to integrity. That's the right to oppose alterations of your work and modifications that can harm your honor and reputation. Say they make a porn version of your work. Well, this is a right where you can always rely on whatever contract you have concluded. And then last, there's the divulgation right. The divulgation right is your right as an author to decide whether, when, and in what circumstances you want your work to be made public. So it's even in some countries, including in Belgium, this right goes as far that imagine you are an artist painting a painting, and suddenly you cannot pay your debts anymore. Your house is sold, and all of your furniture as well, but your work is not finished. You have a right because it's not finished, and there's no one can comply you to divulgate your work, to bring your work in the open, in the public, if you do not think that it's ready for that. Now, these moral rights from a legal perspective are actually a bit understudied. Why? Because there's not so much money involved, so you don't have a lot of cases going to court. But from an artistic perspective, these moral rights are very important because often artists take pride in their work. So it's in fact more important than one would expect. Say, for instance, you write a scientific article as well. You would like to be quoted on your article, obviously, if somebody cites you. Then, exploitation rights, again, that's where the money is at. I could go into a lot of detail, but I'm not going to do that. Generally speaking, these are the big exploitation rights that authors get. A right of reproduction, meaning any form of copying, of reproducing your work, whether that's analog, say a copy machine, or you drawing somebody else's drawing. Well, this is a reproduction in the sense of copyright, so you need permission to do these, to make these operations, to make these acts. But of course also digital reproduction, which is a lot faster and often which happens all the time. Copy pasting something, downloading something, uploading somebody else's work, recording somebody on your smartphone, loading a work inside of your computer to show it on your screen, are actually two reproduction, seeding and leeching torrents for movies that you illegally download. Well, these are all acts of reproduction. Applied to choreography, filming somebody's choreography is a reproduction because you make a copy of somebody's work. But also taking a photograph of somebody's choreography, so one photograph of a choreographic work, as long as the originality of that work is somehow visible in that photo. You can imagine certain circumstances, but obviously will not often be the case, can amount to a reproduction, as long as the original elements are still perceivable or still visible. These rights, these exploitation rights, already exist since the 19th century. So these used to be the big forms, the most common forms where work were being distributed by, or how works got to the public sphere. Yeah, works got printed on paper, so that's a reproduction. They got rented out, landed, distributed, is selling them. But of course, over the last few years, the right of reproduction has gained more and more importance because it was decided that every digital reproduction is also a reproduction, so that makes that reproduction can nowadays be called the most important aspect of copyright. But actually you already hear that in the terminology, because in English copyright evolves around the idea of copying each other. Adaptation, translation right, is the right of making, of adapting somebody else's work. Distribution, as I said, is making physical copies, tangible copies, like printing a book and then selling a book. Well, for the printing part, you need permission for reproduction. For the selling part, you need permission for the right of distribution. And then there's this other very big important right that gains relevance, especially after in between the two world wars, because then the radio was invented. That's the right of communication to the public. You, as the author of a work, have the sole right, has the veto right to communicate your work to the public. And what's a communication? A communication is every form of distribution without tangible objects. So what does that mean? That means singing a song, broadcasting something via the radio. If there are no copies involved, and even when there are copies involved, the transfer, the ephemeris transfer, the ephemeris distribution between 2 points, that makes an act of communication. And then there's a lot of criteria determining to what extent a communication is a communication to the public. I'm not gonna go into detail here, but the idea is that if you are in a private sphere, singing in your shower or singing in front of family members, then obviously you do not need consent of copyright holder of that work. But from the moment that your public, that the audience that is listening to you is becoming fairly large, or is becoming an indeterminate group of people, either physically present or not physically present, so also on the internet, then you are in the scope of that right of communication to the public. In other words, if you put something freely available on the internet, you will actually violate, if you don't have the consent of the right holder, two rights, because putting something on the internet will amount to reproduction, because there need to be some server holding some file at a certain point, and the fact that it's freely available makes it a communication because it's accessible for an indeterminate group of people. Are we still? Okay. Including live performance and access on demand was the terminology that they invented in the 90s to say available via internet. And then is the resale right, but that's less relevant today for choreography. At least that's when a visual artwork like a painting is sold by a professional intermediary seller, then a specific percentage of the sales money is transferred directly to the owner. But that's actually very specific right. Good. These rights are independent of each other, which means that, as I said, one operation can involve different rights. You can also only transfer, for instance, your reproduction right, or only transfer your distribution right. You can exercise them if you have these rights as you please. You can give somebody permission only to communicate your work or only to distribute your work, but not to reproduce your work. And especially the fact that you get permission to do something, for instance, the permission to reproduce something, does not automatically give you the permission to adapt the work, to distribute the work, to communicate the work, etc. What else is there to say? Every time somebody wants to pursue such an action, so somebody wants to make a new reproduction, a new act of communication, again, new permission, new consent of the author is necessary. Okay, what happens if there is a violation of these rights? Then we call that a copyright infringement, also sometimes called piracy, but that's actually not so correct. Copyright violation is also good terminology, or counterfeit, also synonym. Don't call it plagiarism. Plagiarism has nothing to do with intellectual property. Plagiarism is taking somebody else's idea without giving that person credit. And intellectual property rights never protect ideas. So, although in the media we always find copyright plagiarism, no, nothing to do with each other. Plagiarism is taking somebody's idea without duly acknowledging, indeed. So that's something that might be problematic in a scientific context or in a context of education, but has nothing to do with intellectual property. So what if there's a violation? Well, first of all, every violation of intellectual property right, whether there was an intention, whether the person who violated a right was what's called in good faith, so did not know or did not have to know that something was copyright protection, is irrelevant. You'll always be entitled to repair. Repair meaning first, meaning that the court can order that person to stop pursuing that action, stop distributing this work. A court can seize and destruct your infringing goods, and in any case, you can also always be condemned to pay damages. So repair damages. And then, if there are certain circumstances, for instance, commercial aims, or you circumvent technical protection measures, so anti-copying, anti-piracy systems, then you can also face a criminal prosecution. so fines and imprisonment, but in fact that's not a priority in most countries, so this is often more symbolic legislation than actually enforced legislation. Okay. You still with? Okay. Now I gave you these rights. Is that all there is to say about copyright? And here becomes very important. No, because whatever intellectual property rights you are talking about, but especially copyright, you can only fully address a situation, fully make a complete assessment of the situation, if you also take into account the exceptions. And what are exceptions? Well, literally, what the word implies. An exception is when we go back to our ocean. So we were in our ocean of free copying. We have an island on our ocean that are intellectual property rights, and then on these islands there are some lakes. Well, these lakes are the exceptions. So that's the case where the law says, okay, here there should be copyright protection, but in this specific circumstances it would not be just, it would not be proportionate to grant this protection, so we're going to protect somebody else. So here there's a lot less international harmonization. In the US, for instance, there are very broad exceptions. In Canada as well, there's in most systems there is an exception for fair use, meaning that if you transfer, if you transform a work to such an extent that you create a new original work, and as long as you do not enter in direct competition with the original work, you will be able to pursue without a copyright infringement. So they take the case of Fortnite, where the choreography was reproduced in a video game. Regardless of the protectability of the choreography, say that the choreography is protected, then in the US system, the judge will probably decide, and I think that they did at a certain point, that at no point does this reproduction in that video game pose a direct competition for the original work, because the market for choreography and the market for a choreography that is imitated in a video game is not the same. That's a US perspective. I put EU sticker on top of that because that exception does not exist in European system. The European system is a closed list system, which means that if you want to know whether there is an exception, then in every country of the European Union, you have to look into the law and see whether the situation that arises corresponds to one of the situations described in the law. So, for instance, in Belgian law, there are like 35 described situations, and then you have to check, do I meet every criterion? If yes, then you're under an exception. If no, then you are free. Then you are not free, then there's a copyright infringement. Two conditions that always need to be met if you want to apply an exception. First, you can only apply an exception if you are in the presence of a work which you have legitimately acquired. For instance, you can, for instance, I will give you some examples, but you can make private copies. There's a very big exception for private copies, so copies in your private sphere. Can you make a private copy of something that you downloaded illegally from the internet? No, because there's no legitimate source. Second, all of your exceptions only apply as long as the use that you make of a work does not conflict with the normal exploitation of a work. In other words, you will rarely be able to invoke an exception if that if the use of somebody else's copyright protected work could give you a commercial benefit. So as long as you stay in the private, you always need to you always need to pursue non-profit. And then, as I said, we would need to look into every country's list separately to see whether you are under the scope of one of the exceptions. And then there are a couple of exceptions that are interesting. I already told you private use, business internal use will also be excluded, so you don't need permission for that. Non-profit public lending by libraries, another example, they don't need permission to lend out works. You can make more accessible versions of words under certain circumstances for people that, for instance, are visually impaired or otherwise have probability to have access to certain works. So you don't need the author's permission for that. Journalists have a certain privileges. They can copy works even with the view of journalism, etc. And then another interesting one, which is actually interpreted quite broadly, so gives a lot of options, is a citation. So you can quote somebody else's work, at least in the European Union. And interestingly, it is found that this exception for quotation or citation applies to every single form of art. So you can also quote, you can also cite choreography, for instance. The same way as you can sample music, sampling music is a form of citation. However, when you cite, you need to give proper attribution to the author of the original work. Your work has to start a dialogue to some extent with the existing work, with the cited work. So you cannot take somebody else's work or an excerpt of somebody else's work just to draw attention to your work. So you cannot free write on this other person's work. So no gratuitous citing. There has to be a direct link between your point of view and the work where you are referring to. And then very importantly, and that's true for all of the exceptions, proportionality, balance. If you write a work of, let's say, 5 pages or 5 minutes, and 3 or 4 of those minutes or pages are citations, that's not proportional. It cannot be proportional anymore. So there's no maximum number or minimum number for citation, but it has to be proportionate overall. So that's for the exceptions. If I try to put this in a scheme, so copyright, then this is how it kind of works. You create an original work of art, then the law automatically grants you rights, which I listed for you, and then there are 2 options. Either either the law grants an exception and you don't need to ask permission to the copyright holder, but then you need to be able to prove that you are within one of the exceptions of the law, or the other option is that you need permission, and that basically requires always that you will need to conclude the contract. So these are the options that you have.
Eccola lì. Va bene.
So here we have a case that did not make it to court. I think a lot of people will be familiar with this. So this is a case where Beyonce obviously copied, parodied, used work by choreographer Anna Teresa de Keesmaker. Rosa danced. The title of her work is Rosa Dances Rosas. So I showed you this excerpt. What's your analysis? Would you say that this is a copyright infringement based on everything that we know? So.
Yes?
Yeah.
Okay, let's go step by step. First, you saw the 2 excerpts. Is the work that is being copied recognizable in the work of Beyonce? Yeah.
Yeah.
Okay, I think we can agree to that. And let me go back to the let me go back to the list of rights. Okay, and now we have these rights here listed, and the question becomes, which of these rights would you say are violated here by publishing this video on YouTube?
Communication.
Yeah, communication to the public, sure. Reproduction. Adaptation, yeah, that was the ones that I was always also thinking of. And moral rights?
Moral rights, I would say.
Which ones, if you remember?
Paternity.
Yeah,
Which in this case is maternity,
Yeah.
because mater semper certa est, but father, we have some
Yes, indeed, the
troubles there.
paternity right. So then the question becomes.
Integrity and divulgation.
Divulgation not, because divulgate you can only divulgate your
It was finished.
your work
She was
once,
there.
and she had already divulgated.
Integrity.
Integrity, that's indeed open for discussion. Depends on. So that brings us to the next question: whether Beyonce can perhaps rely on exceptions.
The citation.
No, there's no citation.
She didn't make an attribution.
There is no attribution.
Yeah.
Parody and caricature.
Yeah, well, then
No, I don't
indeed it
think
becomes
so.
interesting. Is this a parody?
No, it's not.
Is it meant to provoke humor? To provoke?
No.
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 But you
Plus-
said something about fair use. You also said about different markets. And that's one.
That's U.S. perspective.
Oh yeah.
Yeah.
Yeah, but Beyonce is in the US, right?
Yeah.
And is there another element that we might use against?
No, but yeah, it's very profitable what she.
Okay, so then I think that if you were judges, that you would be
Guilty.
nothing, but Kirmak doesn't really surprise me. I would also say that this is more or less a clean case of copyright infringement. There is no case law about that, so it's possible, probable, that they made an out-of-court settlement, but we will never know because that's classified. So we'll never know whether there was actually a case about that.
But can I just ask a question about that? It's just been bothering me for a long time already. Because in the first part of your presentation you said it's not just that Beyonce took the actual sequences of the steps of the choreography, but she also copied the entire aesthetics of the movie, and the movie also has an author.
That's a great thing to say because that's actually the next thing I wanted to talk about. That's the neighboring, but indeed, she also obviously violated the film director's original choices. Well, they also copied those. So absolutely right, yeah.
And the costumes,
Yeah.
Scenography.
Many.
Yeah.
It's many infringements, I would say.
Yeah, it's true. But of course, I now only specified the choreography. I
Yeah.
zoomed in on the choreography, but and at that point you're
And
absolutely right.
by the way, just so that you know, there's also another choreography of Anne-Theresa in that video being copied, which is Achterland. Yeah.
Okay.
So it's about two performances.
No, not only guilty one. Guilty two, which is devilish, eh?
Now I'm asking the organizer, can I still continue because I'm now running over.
Yes, I think we can take 10 more minutes because we already took a break of 10 more minutes. if
Yeah,
that's
Yes.
I still have a lot of blockchain to go to. But, I'll make it as short as possible. I will just finish off the copyright part because another phenomenon that I did not mention yet, you see private initiatives, is, okay, you're an author and you are now entitled to all these rights. What do you do with these rights? You can use them as the law intended you to, so you say I don't give permission to anyone unless they pay me a fuck ton of money, which is one option. But there are also people that are more open-minded, that want to use their rights in a different way, which is absolutely their right to do, they're not obliged to. And that's why we had some evolutions over the last decades, which you might have already found on the internet. These are private initiatives where authors say, I voluntarily give up part of my rights, or I grant a license to anyone. Anyone who wants to use my work is able to use my work. But again, no one is obliged to do that. So you're not obliged to grant a license like a Creative Commons license or a copyleft license. These are private initiatives. Copyleft is more for software, but also exists for other works. It's where you say, look, I wrote this piece of software, anyone can use it from now on, I don't claim anything. Can you do that in a Belgian system, based on what I said?
No,
Why?
because you can either claim for the part of yours, you said no.
Yeah,
So you can recognize, this is what I came, as far as I
but
came.
as can you give them away? Can you give away your rights?
Yeah.
Not your moral rights.
Yes, indeed. As long as you always keep your moral rights.
Però
Pay attention.
this is what.
Okay, Creative Commons is a little less drastic than copyleft. That's where somebody says, okay, anyone else can use my work, but under certain conditions. and this is valid from a legal perspective. And then they invented these pictograms to simplify these conditions. So if you see this, for instance, it means that you need to attribute the author. You have to say that this work was made. This is a work made by this person. Means, if I'm not mistaken, that if you share this, no wait, this means that you can only make, you cannot make derivative works, if I'm not mistaken. While this could mean that you can make derivative works, but if you make them, you also need to put them in a Creative Commons license. And this means that you cannot, you cannot make profit out of it. Is this valid? Yeah, this is valid from a perspective. The same vein, open access publications is all in the same trend of making things available that would have been copyright protected. Whether you want to do that, not want to do that, is up to you. But sometimes it's forgotten. Sometimes you see fierce advocates against copyright. But bear in mind that, for instance, licenses like this only work because we have copyrights. So without our copyright system, you cannot have a license like that, and just anyone can copy whatever you want without attributing.
Yes.
So to finish off, I found this publication. So what we see here is,
look at this name.
for instance, a typical copyright notice. Is this valid? Yeah, so it means that unless otherwise proven, we can presume these authors to be the authors of this work. And then what we see here is this is an open access article distributed under the terms of Creative Commons attribution. So this is actually a license that is valid, and then Creative Commons has a website where it shows their terms, and then if you look into that, so here they make short
Very
short
generous
abstract
people,
for lazy people, and then here for the lawyers under us you find complete terms that would say that, for instance, if you share licensed material, you retain the following rights and blah 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 blah. So you see, this is how it works. Okay, so what happened in again, a lot of things happened in between the two wars, and one of the things that happened is that as it became possible to record things, people that used to be paid to do performances no longer were paid to do performances, because instead of contracting a pianist, piano player, sorry, and a singer in cafes and bars, bar owners just switched on the radio or bought phonograms. So after a while, these people, these performers, these musicians, these artists, were felt to being replaced by what then was top-notch technology, the gramophone and the radio. So against that background, as these people do not make free and creative choices, are not authors of the works that they perform, or obviously not always are the authors of the works that they perform, they thought, okay, we should protect these people to some extent anyway, and that's why they created something called neighboring or related rights. Why are they neighboring? Because they are not copyright, but they are neighboring rights. They are a light version. Actually, they should have called it copyright light version or something like that. Okay, so what do these rights protect? Well, first of all, musicians, and then now you're thinking of Beyonce and co, but also the person standing behind Beyonce, the drumming or playing the guitar that nobody ever, that nobody will ever know. Well, this person is also protected by these neighboring rights, and those are actually the people that are really protected, the ones that are actually intended to be protected by these neighboring rights. What else do we have? In the same category of neighboring rights, broadcasters, film and film producers and music producers, and of course, most importantly, also dancers will be protected by neighboring rights. And when we talk about neighboring rights, what you have to know is that unlike copyright, the neighboring rights is actually an umbrella term to indicate a couple of different specific intellectual property rights. So a bunch of different rights which all have their own specific rules. So which rights do we have? At least in the EU system, phonogram producers' rights, producer of a first fixation of films, press publication rights, broadcasting rights, and then performance rights. And all of these right holders, all of these neighboring right holders, have rights in a certain subject matter. And where for copyright, the subject matter was called a work. Here, this subject matter is called differently. A phonogram producer has rights in a phonogram. Producers of a first fixation of a film have rights in a film. Broadcasting organization in their broadcast, and performance in the fixation of their performance. Now you may ask yourself, yeah, phonograms, I mean, we are 2022, why would we protect phonograms? But that's a mistake, because phonogram is defined as every exclusively audible fixation of sound. So, a file in iTunes or a file on Spotify, yeah, for instance, would also constitute a phonogram in the sense of this definition. So the producer of that phonogram, of that file, will have protection. Same film is actually would be the same definition, but then it's not exclusively of sound, but there has to be an audiovisual element. Now, for choreography in specifics, no, I'm going to first add something more to that. I already told you about accumulation. So one object can have different rights. Well, say there's this video clip of let's say Beyonce to make things easier. The person who made the choreography of that video and the director of the video will probably be authors, because it's an original work. Second, the investor who invested in making that video will be a producer of the first fixation of a film, so they will be granted these rights as producers. As far as music is used, which will be the case, of course, in an audiovisual, in an audiovisual video, in a music video, as far as music is used, there will also be rights involved by the phonogram producer. That will be, for instance, Sony Music or Warner's Music, the ones that took the investment of putting this on the market. And then there are the artists that are in it, not only Beyonce, but also the other artists that are visual, but also the ones that are audible, so also the piano players, etc. They will also have their rights as performers. So you see, what does that mean from a practical perspective? That means that you need to have permission of all of these individual people to go to action, to perform acts that are protected by these rights. But obviously, what happens in practice is that, depending on the bargaining position that you have, usually this producer that will be, let's say, Sony will be both phonogram producer and film producer, and Sony will have concluded extensive contracts with all of the people that all of their rights are transferred or licensed to them. So of course they are bundled, but that does mean that there are negotiations and that these people should at least be reimbursed in that contract.
Can I ask you
Yeah,
something
sure.
very quickly about the production of a film? Because I can feel that there is a kind of a trend, actually. If you go watch a film, let's say Brad Pitt is starring a film, that he's also the producer of a film.
Mm-hmm.
That, like, most of these big actors, they became producers as well of their own films. And does that have to, I was wondering if this has to do with the copyrights or kind of royalties that they would get from
No,
from
probably
distribution of
not,
the
because
film.
I'm very sure that whatever producer wants to contract a Brad Pitt, that Brad Pitt will probably have a very good impresario that makes his legal contracts. So whatever you do, you will always pay to Brad Pitt. So I mean, there's no legal nor economic. I think it's really a matter of artists being bored of being
Of
an
doing-
actor, yeah, and wanting to do something
Another
else.
business. Okay.
Also, it's maybe a more rentable business. I mean, I suppose there's more to
Yes.
earn with.
Or maybe they have more control over what they
Yeah.
act on and what comes
how it's
out, so
distributed,
they
yeah.
kind of
Probably
become
fed up with
directors
difficult
without
directors. Yes,
becoming.
please. What? Okay. Good. So you get what rights do you get? Light versions of the rights. So these are the ones that I think are most interesting for choreography. Obviously, because I leave out a part of music. Film producers will get a protection of 50 years after the fixation of the film, so the moment that the film is created. Which rights, rental and lending rights, reproduction rights, distribution and communication to the public. More interesting for you perhaps are the rights of performers, because performers are defined as actors, singers, musicians, dancers, and other persons who act, sing, deliver, declaim, play in, or otherwise perform literary or artistic works. Not every country in the world has performance rights. Why? Because especially in countries, let's say in underdeveloped countries, it's less interesting to grant a lot of IP protection, because it's a given thing that countries grow as long as they can copy without asking for permission. And technology evolves mostly by first copying each other and then building upon that. So you will not find performance rights in every country, but in the EU and North American system, you will have copyright protection. Performance rights protection. Who is protected as a performer? Only people that make artistic contributions, so who actually play or otherwise perform a work, not technicians. So somebody who does a technical job, although important for a performance, will not get protection as a performer. A performance is something that is either visible or audible, which is quite obvious, but that doesn't mean that a performer needs to be visible or audience during a performance, because also the director of a choreography, say there's a dance and either it's the choreographer is him or herself, or giving directions. Well, just like the director of a theater play, if this person does an artistic addition, puts artistic elements in the performance, there will be an this will also be a performer in the sense of the law, and these rights will also be granted to this person. What else? The conductor of an orchestra, for instance, will also be a performer, although not audible, of course, on the phonogram. Irrelevant whether you are a professional, whether you are an amateur is not relevant for the definition of a performer. Whether you are also the author of your work, and whether the work that you perform is or is still copyright protected. So even if you play classical ballet by Tchaikovsky, you will also get entitled to protection. Conditions for protection: there must be a fixation of your work. So here there is an absolute criterion that your work needs to be fixed in something before you can get the protection, and there must be a performance. And then the question is, what is a performance? But let's not go into detail there. Which rights does one enjoy as a the term of protection here again is fixation plus 50 years, but because of lobbying by the music industry, the situation gets quite complicated, because if you are a performer and within the first 50 years after fixation of your work, of your performance, that fixation is published or communicated to the public, then it's from that moment of publication or communication to the public that you get 70 years. If within that period your fixation is published or communicated to the public, and it's not only sound, so it's audiovisual, like would be the case for choreography, then it's only plus 50 years from that moment. Yeah, I know it's completely, and this is the simplest way that I could put it in a slide, but it's in the law. It's horrible. It took me a while to find out myself what it exactly means. But the thing is that there's a huge discrimination between audio only and audiovisual artists. 2 2 more minutes? Yeah. Okay. Because then the question is, what rights do you get as a performer? Depends from country to country, and as you could already imagine, there's a very strong differentiation on the international level between visual performers and sound-only performers. Because sound-only performance musicians have had more lobbying going on for a lot of years. Although in 2012 an important treaty was decided, the Beijing Treaty on Audiovisual Performances, and countries that adhere to that treaty promise that they will give the same rights to audiovisual artists as to audio-only artists. Which countries are part of that treaty? All EU countries, but that's not a problem because in the EU there has never been a discrimination between visual-only, audio-only and audiovisual performances. Other countries included are Ecuador, for instance, but Brazil is not included. Moral rights, there's like this minimum hardcore set of rights that are granted to performance. So there's the right to paternity, but you do not have a right but your right can be, your right only counts as long as the omission of your name is not dictated by the manner of the use of the performance. Say that you're playing in a classical orchestra, then you cannot expect that when the song is played on the radio, that they will read the name of all of the people that were in the orchestra. Integrity or respect, you only can act against distortions, mutilations, and other modifications that are prejudicial to your reputation. And the exceptions, we have similar exceptions as in copyright law, so for that I can refer back to what I said already. And then the rights are also almost the same as in copyright, but there's an extra right. You are the sole person entitled to decide whether your work will be fixed in a carrier, so right to fixation. And then what you see here, there's no public lending right for performance. And then communication to the public. Then we see that the law takes a piecemeal approach, meaning that there's not a general right to communication to the public, but there is a right to either allow or not allow that your live communication is that your performance is being communicated live. Say that you are having a concert and public broadcaster wants to communicate your work live on the radio, then that's a right that you have. But the moment you put it on a CD or you put it on Spotify, the radio can do whatever they want with it. On the other hand, you also have a right to decide whether or not you will put your work, you would put your fixed performance available on the internet. And then this last right is like to compensate the fact that the right to communication to the public is not always there. There is this right which you cannot transfer, which you cannot give up, to equitable remuneration. That means that if somebody uses makes communication to the public on a broadcasting scale, on the basis of your fixation, so for instance radio broadcasts a song, then you have a right not to decide whether the radio is entitled to do so, because they are entitled to do so, but you have a right to an equitable remuneration to a certain. Okay, well then I'll move on, and this is actually a bridge to my next chapter, and then I see it, I put in my slide, which is going to be after the break. That is a short excursus to the question of choreography, digitization, NIP, before we go to choreography, blockchain, NIP. So as I already told you, there's this new phenomenon of avatars reproducing choreographic movements. And I got a great website, well, a great example of Jorge, which is Meta Movers, so which has a website that sell NFTs, but the NFT part is I'm gonna get into it in a minute. And then the question is, okay, if we have an avatar moving like that, can this be an IP infringement? Well, let me ask you, copyright-wise and performance rights-wise, do you imagine that this is your choreography? Imagine that this is sufficiently original choreography. Imagine that you made a video of yourself performing that choreography. then first, is this an infringement of your rights as an author? Is that an
Yes.
infringement of your copyright? Yes, you say, why?
Because you say we
Yeah.
fix it. So, and we also put the right amount of
Originality.
originality. So, and if someone sees the video, as for Beyonce, it will see that it is our.
It's recognizable. Indeed,
Yeah.
that's
I wonder if where your question of simplicity will go into
Yeah.
this.
yeah, it's a good question. A good question.
Yeah.
It's a good question. But we're not going to address it.
Because, how do you
second-
count the steps on it?
Yeah, I know. Second question though. So you made a video of yourself performing this. And is this then a violation of your right as a performer?
As a
Someone? I already told the lawyers in the room that if nobody responds to my question, I will appoint them to answer them.
What do you think?
But
Well,
Jorge
you just gave a definition of a performer.
Yes.
Like, so I don't know how this goes. Like if
yeah, because it's human on human.
Yeah.
This discriminant, no?
The thing is with the performance, the right to performance only protects the exact reproduction of your performance. So it would only be if they reproduce or communicate, in this case both, reproduction communicate your images of you performing, so your performance, which is fixed, that is, will be an infringement. But here, they did not use your images in any way, and if they use them, in any case, they are no longer recognizable. Okay, they use your choreography, but that's copyright.
so this could be a parody.
In copyright, yeah, maybe in copyright. But from in no way can this be an infringement of your performance rights.
If they use motion capture data of a performance to animate this figure, is that copyright infringement?
Copyright.
Performance.
Well, if you have a performance which is motion captured and then this motion is transferred to this figure, avatar, is that?
Can you give the full case? So,
Well, say you have a performer who in this room is performing this dance.
Yes.
And the motions are captured. And these motions are used to animate this figure on the screen. Is that a?
then you need to make a comparison between the fixation of the performance, which will be video.
No, it's motion
No,
capture, so
it's
it's
motion
data,
capture.
it's sensor data,
Yeah, it's data.
coordinates in space.
They stole our data.
It's data.
That's
It's a
good. That's the
notation.
next,
It's
next,
a
the
not-
next
No,
slide.
it's a form of notation. It's a form of actually storing a form of notation.
Yeah.
Yeah, interesting. Would it be a violation? I would say no, because the performance is actually, the question is whether visually in this case, the visuals that you had and the visuals that were made that are being used by somebody else, whether they are still recognizable.
But it's only the visuals that are in question. Then.
What?
It's only the visuals. That
If we're talking about performance rights, not about copyright. The performance rights.
Neighboring rights.
Okay.
So we're talking about the neighboring rights. Yeah, sorry. It's from a copyright perspective, indeed. Regardless whether you digitize somebody's choreography or whatever, it's and whether you put it on an animated video or you make your own or you find yourself a performer to perform it for you. That's of course an infringement because
It is copyright.
yeah, because it's copyright protected.
But the performer, it's not.
It's not the same performer. That's
Yeah,
actually
but-
basically it. Yeah, it's not the same performer. Does that make any sense? Yeah, performance rights are a bit.
But there was, if it was mock-up data, there was a performer did it before, and
But that's irrelevant because the person is no longer recognizable. Even the
the
data would not be
movement-
recognizable.
the movement could be though. The movement of the person could be quite.
We'll have, I feel that we have a new PhD coming up. But it's indeed an interesting. These are interesting questions. I cannot give you an indefinite answer to that because these are new
sure.
technologies as well.
Yeah.
But it's good food for thought. Maybe I should try to.
there's a very maybe just to there's a very interesting case about this film Happy Feet. You
Ah, yeah, the penguin.
The penguin. Because with the Happy Feet, there was a tap dancer that was motion captured and was reproduced as a penguin in the film that became very... Yeah, and he actually owns all the movements of the penguin. The penguin moves like the tap dancer, but the voice of the penguin was Elijah Wood.
Yeah, it was on...
and it was only credited in the film as the penguin is Elijah Wood and not the tap dancer. And they created like apparently a very interesting case about the copyrights and who was that character really? The voice or the movements?
Yeah, because
clearly
there was
the image is just a penguin, so that you only had the movements or the voice to understand like what the performer was.
Yeah, star, you know.
Voice will be protected as a performer as well, of course, because that's somebody who impersonates a work. But the question will indeed
But
be...
a dancer as well, no?
Yeah, this is a good, a valid point in that.
Yeah, because in that movie, the part is that they were saying that a penguin should be famous only for singing, because penguins sing. And actually he was super because he could dance. So not acknowledging the dancer that was really doing that.
It's a game.
It's really following the discrimin kind of...
yeah, it's the same kind of discrimination with the audio and the audio video.
Yeah, there's indeed an interesting point. I hadn't looked into it that far, but actually it's very... I think that's a right point.
Oh God.
But I like your approaches to it. Good. And then I permit myself to go into the next topic, and that's blockchain applications for IP. What is blockchain though? I'm not going to start with that because you're probably all aware of blockchain technology. You probably know it a lot better than I do. So what we have seen though is that a couple of years ago, especially 4-6 years ago, the idea of blockchain and the law, and more in general, more specifically blockchain and IP law, intellectual property law, that this could be a thing. Why? Because in case you didn't know, there are some characteristics that are attributed to distributed ledger technology that make blockchain potentially interesting for IP cases, notably transparency, public ledger, blah blah blah, and unchangeability or temper proofness is also referred to, and then buzzwords like trustless trust, disintermediation, and distributed nature of the ledger. We all know the concept behind that, or do we know all these concepts behind that? Yeah, okay. Good. You know the risk of double spending? The blockchain prevents that you give the same token, that you spend the same token twice. Well, that was thought to be interesting, especially for an IP law perspective. So what we done saw is that my slides are in the wrong order. The lawmaker, so the policymaker, did not do anything. So there's no such thing as blockchain IP law. So only thing we have here are some private initiatives of people or companies that thought, blockchain can revolutionize IP. Let's do this. So and then you have different applications whereby the token and the object of a blockchain transaction token, something that means something in a blockchain, is always given a different interpretation, or is given a different meaning. And then we see that there are some initiatives that have passed, like for instance, I'm going to wait for this example. Some people had the ideas to make a register, a blockchain register with unknown authors, works with unknown authors, and works in the public domain, so that you are sure that the work is in the public domain, that you can use it. What all of the proposals have in common, though, is that it's never the idea to put a work as itself on the blockchain. Why? Because that would be far too heavy, would mean that this work is distributed everywhere all the time, and that would take too much space. Plus, would be a reproduction and a communication to the public every time, which would need consent of the author for every single transaction. So every time the blockchain is altered. Other potential uses that were thought of is using digital DLT to track who added what to a jointly created work. That might be interesting because imagine we both have an account and you work in the same project. Then, thanks to blockchain, you can, without changing, without the possibility of changing something by retrospect, you can see who added what at what time. If you do that, you would need to conclude a clear contract with your joint authors, though, saying that what we put in the blockchain is what we consider true unless the opposite is proved. Other interesting feature of blockchain is or would be the timestamping part. So the fact that you put something in a blockchain, you can use that based on the fact that blockchain usually has a timestamp. However, beware that courts are not obliged to take that into account because timestamping is still always refers back to private initiatives, and there's no way to prove that that was not tampered with at the moment that the timestamp was made. But it can be an important indication. Then digital ledger technology for for digital rights management. So the idea is that through blockchain applications, it would be possible to indicate the name of authors and performance of a work without you being able to change it later. So then you have like Bitmark, Blocure that were startups that started a couple of years ago, but they still are in the development phase, so they're probably not going to get out of that phase anywhere soon. Why? Because the idea that you can put certain information in the blockchain and then make it unchangeable is forgetting the fact of that is not taking into account the so-called garbage in, garbage out effect. That is, you know, the garbage in, garbage out effect, I suppose. Yes. No, is the fact that if you put wrong information in a blockchain as from the beginning, well, then you're not going to get it out. Yeah? So you only get garbage out of it. And that's a problem from a legal perspective, because say that somebody either on purpose or unwillingly puts the wrong name, the wrong author in a blockchain and says this work is by this person, well, there's no way to get it out because it's a blockchain. So the information cannot be altered afterwards. So that's why these projects can never work, especially because who is an author of a work, who was the performer, and what is this person entitled to is often, very often, only determined afterwards in court. And if you cannot change it anymore, then of course it's useless. Then your blockchain becomes obsolete and irrelevant. Then in the field of my PhD, I'm going to skip those. There was this idea to, these are all examples, to facilitate the ability to transfer digital stuff from one person to another while making sure that the first owner of that stuff would no longer have access to that stuff. So imagine that you buy an ebook, you want to resell it to somebody else. Well, you cannot do it from a legal perspective, but could you do it from a technical perspective? Well, you would have to make sure that the first person does not retain a copy, and then it was claimed, but you can solve this to blockchain because you will only have access to a work if you are the account holder that has a token that allows you to enter a work. Am I going too fast? No. But so that's the idea, and that's where that's where NFTs come in. That's the idea that blockchain can be used to create what is called digital scarcity. So data are rivalrous in nature, meaning digital data are non-rivalrous in nature. So most things around us are rivalrous, meaning if I use them, if I consume them, nobody else can use them at the same time. That's a rivalrous good from an economic perspective. But data are not like that. Data are non-rivalrous. Multiple indefinite numbers of people can use the same data at the same moment, and the data will not be consumed at the end of their operation. So that's fantastic from an IT perspective, because that's why data are so easy to transfer all over the world. But that's problematic from an IP perspective. because people can copy each other easily, and we know in production we don't want other people to free ride on our what we did or what we made. So the idea was, with distribution ledger technology, we can create digital scarcity. We can actually turn data into scarce goods, into goods that can be exclusively owned by someone. However, I would say that that plan was doomed to fail, and we have only seen failures in these startups until now. First and foremost, all of these initiatives are private, so there's no standardization. Everybody creates their own new system, but they cannot cooperate. So as long as we don't all agree to get to one same system, and as long as the law doesn't oblige you to take one system, yeah, anyone can do whatever outside of the system. So you would have to agree to one blockchain system, otherwise you cannot proceed. So, as I already said, garbage in, garbage out. A lot of things happen outside of the blockchain. Are you allowed to do transactions, make contracts, conclude agreements outside of the blockchain? Of course you are. Nobody obliges you to, can oblige you to use the blockchain. So that's what's then called in IT terms that is so-called off-chain information that is not entered into the blockchain. And the moment that that happens, your blockchain is no longer relevant because it doesn't show you the actual current stance of the situation. So garbage in, garbage out. And then, as I already said, law is a human science by definition, because in the end a judge will always make a balancing exercise, and you don't know in advance whether a solution will be positive to you or will not be. So you cannot always predict. It's a common error, especially by IT specialists, to think that you can put that law are rules, that it's just if then, if then, if then. But it doesn't work like that. You cannot predict law, because you cannot predict human behavior, and because, as I now showed you, what's original, when is a work sufficiently original, what's a parody, what's a citation, these are not fixed terms, and they are also subject to evolution, and that's good because law needs to evolve together with society. So the idea that you can put things into these if-then systems is, I think, wrong. Plus, so imagine you say, okay, only people with a token can use an ebook. So only you can call yourself the legitimate owner of an ebook, and you can transfer it to another account. Well, in theory, this solves the problem of double spending. You can only sell your ebook once to somebody else. But if somebody wants to make a copy of that ebook and is able to do so outside of the blockchain, they can still make a copy outside of the blockchain. So actually the problem is absolutely not solved. It's only at the point where you say, aha, I found you made an illegal copy of this ebook and it's not registered in the blockchain. Of course, at that point you can say, okay, you should have registered it in the blockchain, so I can presume that this copy is illegal because it's not registered anywhere. But that would mean that you first have to find where infringements take place, and actually that just brings us back to the current situation, because the problem is not so much in IP, but in the fact that because data are easy to copy, because data are non-rivalrous, that it's very easy to spread IP protected material without asking for consent. So unless we get, then there's also privacy concerns, because the obvious solution from an IP maximization perspective is that everyone gets access to each other's computers to check whether there are copies of your of other people's works, illegal copies on your hard disk. But of course, then we get to a Big Brother situation where large IP companies can check up on you, and nobody wants to get in that situation, of course. So good ideas in theory, but not very well thought of. So unless we all spontaneously agree to one solution of blockchain, and we say only things that happen in the blockchain are legitimate, we will never get to a point where this blockchain thing will mean anything for IP. Okay, non-fungible tokens then. I will, you know the crypto kitties? No? So, you know what non-fungible tokens are? Okay, then I'll skip the so already exists since a long time. You know that when an NFT is created, they create a link with the metadata is created where a link is made to a publicly available artwork. We also know that NFTs are usually made available via platform websites. This is one of the first examples of NFTs ever created. Crypto kittens, where the theory was that you could own a virtual cat. Later, crypto punks in the same idea came across. And then actually the question is, what? I'm going to skip a bit, obviously. So these are new, or more recent phenomena, especially since the 2020. We have the idea of non-fungible tokens as a means of investment and as a means to own art. And this brings me to the. So these are examples of NFTs sold for tremendous amounts. Have you seen these examples as well already?
Not in this course, though.
No, but you are aware of them. Yeah.
No.
Okay. Was that a yes or a no? No. Okay. So people buy this. Okay, that's the thing. They buy an NFT, but everybody knows what an NFT is.
Yes.
Yeah.
Okay. Two questions: can an NFT infringe IP rights? First question, I'll just give it away. Yes, of course. You can make, you can use somebody else's work and make it into an NFT, and obviously that's an infringement. Then you can discuss whether linking to something is an infringement. Probably not. But as soon as you ask money for somebody else's work, then it's already an infringement of their IP right. A very different question, that's the last question of today, is what does it mean if somebody says I own an NFT or I buy an NFT? So we see that this is the point where we start from, is that from so what is said often on these NFT selling websites is that you own your NFT. So then the question is that true? Again, on Rarible, it says NFTs prove ownership of a unique digital assets. Brings us to the question, yeah, what does that mean? Owning something like a token, what does it mean? Owning data. Well, the first question you can ask is whether you can call yourself, like I already said, you can be the owner of a book or of a chair. Say, can you call yourself the owner, a proprietario? Can you call yourself the owner of data, of a digital file, of digital assets, of digital commodities, or of an NFT, or whatever? No, ladies and gentlemen, there is no such thing as ownership in data. Data cannot be owned in the current stance of the debate, at least that's the majority view in Europe and in the US. So statements as you own your NFT are just completely true from that point of view. So, and this is what I wanted to warn you for, what do you do when you buy an NFT? When you buy an NFT, then what you do is you conclude a contract. That's the only thing you actually do, you conclude a contract. And what's a contract? A contract is like basically any agreement between two parties. And what agreement do you have? Well, you agree that this is a token and that this token means something. But what that something is, that's not defined. So that's up to you and your co-contracting party to determine. So what exactly do you agree on? Well, that completely depends on your contract. For instance, in Meta Movers, I found that, so as a project that I cited before, that owning an NFT basically only means that you will have priority access to buy tickets for shows, that you will have free access to live streams of shows, and that you will have priority access to special online events. So that's the thing that you get, whatever that may mean. Example of OpenSea then. So if you look into the terms and conditions of OpenSea, it's there, always on the back. Then you will find, apart from the fact that you as a user acknowledge that your NFT can become completely worthless, and apart from the fact that you give a license to NFT to make copies of the works that you upload on NFTs, there's actually nothing in these criteria. They just say that what you get is what you agree on with your co-contracting party. So that means that if I buy Jorge's NFTs tonight for 4,000 euros, then what I get back, that's only determined between what he tells me that he will do for me in return. So that can be, for instance, I get a right to use his video, or I have a right to use the dance moves in his video, I get a license on the choreography, or that he just, let's say, just agrees to buy me a coffee in return for my 4,000 euros. But nothing determines, nothing else except for our agreement determines what I get instead. Then you would think that other platforms like Christie's, which is an international auction house, which sold this work for 69 million US dollar, that their terms and conditions would be more specific. But if you look into them, they say NFTs are provided as available without warranties, and that they disclaim all implied warranty, meaning that they don't give you anything. That's basically what they say in this contract. And more, they say that ownership in NFT carries no rights other than property rights in the law. It means nothing. It means that you have a right to be registered as the account holder of an NFT. So that's what you pay for, to be registered in the blockchain as an account holder of an NFT, but nothing more than that. From license perspective, then, same Sotheby's. I have seen no contracts with regard to NFTs that actually gives you a license to use the work that you are buying an NFT of. Quite the opposite. Often you're actually excluded from using that work, which makes me think that what are you buying? What are you buying? Because the thing that you buy, or a thing to buy, you would expect to buy a license, an exclusive license, or even to have these rights on that copyright protected work transferred to you. But no, in practice you do not get these rights. So you would have to conclude them on a very case by case analysis.